Thank you very much, Denise. I think with the protestation of Antonio, my time here was much better, and we really enjoyed our time here with my family, my 8-year-old and my 4-year-old daughter. I think Hawaii is part of us now. After leaving this place, my son forced me into buying a glove so that he can explain to whoever cares when they come to our house his trip to Hawaii. So Hawaii is part of us as a family. Yes. So I wanted to talk to you about how courts in Africa generally have handled the question of biodiversity and water rights. I know it's a very big task to do in 20 minutes, but I'll try my best to stick to the 20 minutes. My court is stationed in Arusha. Arusha is one of the most beautiful places in the world. It ranks maybe second to Hawaii. And it's one of those places where you find some of the best national parks in the world. There's Serengeti, there's Ngorongoro, and then there's obviously Mount Kilimanjaro, which is not very far from Arusha. The court is a regional court. It's called the East African Court of Justice. It was established by originally 3 countries, that's Kenya, Uganda, and Tanzania. Then later on, Rwanda and Burundi joined the East African community, and now we have South Sudan, which joined 2 years ago. So there are 6 countries which are members of the East African community. And by virtue of those countries being members of the East African community, the jurisdiction of the East African Court of Justice applies to them. Initially, when the court was established, it was believed that it's going to deal with questions of common market and customs union. That's free movement of people and goods. But when the cases started coming to court, it was quite interesting that actually most cases which came to court dealt with questions of human rights. And we also dealt with a question to do with protection of the biodiversity, which you find in the Serengeti. I'll explain that in a moment. I'm sure I've explained this to some of you. I hope you don't mind me repeating this case. But it's quite interesting what happens in that part of the world where you live with this beautiful biodiversity and some of the best species, some of the best national parks I talked about. I'll begin with a story of one day which was in the media. A giraffe mysteriously disappeared from Ngorongoro, and it was traced to have passed through the Kilimanjaro airport. But up to today, there's no trace of who brought it, and the people at the airport still confess that they didn't see the giraffe going to wherever it went. But it was traced, I think, all the way to Saudi Arabia. And it was alive, so you can imagine a giraffe being taken from the Serengeti through the airport all the way to another country. And yet there's no trace of how it ended up where it is now. So those are some of the threats that you find in that part of the world. There's also the alteration and loss of the habitats. I think this is common to most parts of the world. There's introduction of exotic species and genetically modified organisms. We see this happening quite often because unlike Hawaii, where you have to pass through a lot of security in order to see whether you come with an exotic species, this is not the case at the airports. They look for different things, whether you come with a lot of whiskeys which they should test, but you don't find them caring a lot about the exotic species. And this actually is a challenge with the biodiversity in that part of the world. Pollution, of course, is a major thing now. There's climate change, which is affecting the biodiversity. But also very important to note is that Africa is very ripe for mega projects. come to Africa, if you don't come to Africa in 2 years, when you go back, it's a very new place for you because of these mega projects which take place. And it's not certain that the requirements of the protection of the environment is taken into consideration. And I discussed one of the most interesting cases in one of the East African partner states, which was decided last year. That's a case which was decided in Kenya. So how do cases end up in court in this part of the world? For us at the East African Court of Justice, it's by means of a treaty, because the East African Court of Justice is a treaty-based court. So we have a treaty which establishes the court, and it gives the mandate to the court to deal with a diverse number of subjects, including environmental law, because there's a whole section in the treaty on environment. So far, the court has only dealt with one case which had environmental aspects to it, and that was the famous Serengeti case. The United Republic of Tanzania wanted to build what was referred to in the court as a superhighway. And when the case came to the first instance of the court, the first instance permanently injected the court from the Tanzania from building that road, because all the evidence before the court showed that it's going to have a major impact or a significant impact to the biodiversity of the Serengeti. But when it came to the appellate court, and this is where I sit as a judge, Tanzania argued that the treaty provides for you can only challenge an action of a state. And Tanzania argued that there is nothing which has happened. We've not started chopping trees. We've not done anything to start the project. So why should we be held to the standards of the treaty? Yet the treaty provides for an action of a state. Technically, the appellate division agreed with Tanzania that there was no action of a state yet. And we went ahead to enumerate what an action of a state would be for purposes of these mega projects. And the court put in place a number of what they call red flags on when a certain action can be attributed to a state as an action of a state for purposes of the treaty. And one of the red flags that we pointed out was that if you see a project being advertised or a tender being made for companies to come and build the road, then that's a red flag. However, the appellate court did something which has been referred to by some of the people in academia in that part of the world as controversial. The court decided that for purposes of this project, even though the threshold of an action of a state has not been reached by Tanzania, you are still permanently injected if you ever reach that threshold of an action of a state. So that was the only case that we decided, which is somewhat considered to be controversial. But how else do you deal with cases of the environment if you don't have to think outside the box once in a while? Then, in that region of Africa, yes, we have regional courts. We even have an African Court on Human and People's Rights, which has looked at environmental courts in the perspective of human rights. But we also do have a lot of domestic courts. I told you that in East Africa alone we have 6 countries. They all have their own domestic courts up to the Supreme Court. And most of the constitutions, actually all of the constitutions in East Africa, have a right to a clean and healthy environment. So this right had not been tested before in the courts in East Africa. I've not seen a case which has tested the right to a clean and healthy environment. But there's a very interesting case which took place in Benin, now going out of East Africa to West Africa. It's a very interesting case because this case went all the way to the Constitutional Court. We are used to constitutional courts dealing with questions of annulling acts of parliament. But this was very interesting in the sense that there was actions of a company were challenged to infringe Article 27 of the Benin Constitution on the basis that the activities of that company infringed Article 27 of the Constitution of Benin, which provides for a right to a clean and healthy environment. This was quite interesting because the Benin Constitutional Court set aside the actions of this company. Very interesting because it's the first time that we see a constitutional court looking at activities of a company as opposed to acts of parliament which are not in line with the constitution. So this is a very interesting case where a constitutional court looks at the activities of a company and decides that their activities are against or are in contradiction of Article 27 of the right to a clean and healthy environment. And the court overruled the activities of this company. This is very unique. Then, obviously, just like any other part of the world, there are some legislations in Africa for clean air, water and land pollution, natural resources, statutes, and so on and so forth. And a number of cases have been brought using these statutes. I don't want to go into details of this, but maybe just to give you a very significant example of a recent case in Kenya, which came before the Environmental Management Authority Appeals Board. This case was quite interesting because what was being challenged was whether the public participated effectively during the formation of or during the drafting of the environmental impact assessment. So the government of Kenya wanted to build a coal power plant on the seashore of Lamu. Some of you have been to Lamu. The city of Lamu is a UNESCO protected heritage. So they wanted to build, the government wanted to establish a power plant. There was an NGO called Save Lamu. It's an NGO which was established only for saving Lamu. So it went to the appeals board and it argued that, number one, there was no effective public participation. And second of all, the traditional way of looking at the environmental impact assessment left out a very important aspect of climate change. And the appeals board agreed with this NGO, with the applicant. And the basis for this was that the comprehensiveness of the environmental impact assessment study did not excuse the failure to carry out a proper and effective public participation. That was one of the grounds for nullifying this environmental impact assessment. And then another ground was that there was a challenge to the completeness and scientific sufficiency of the environmental impact report that resulted in the license which was issued by the Environmental Management Authority. So the environmental impact assessment was set aside for these two important reasons. So some experts had made some calculations and they had said that if the power plant or if the coal power plant is developed, Kenya is going to exceed its emission of the greenhouse gases by 700% of what they have already, because it was a mega project. But at least for the moment, the tribunal wanted to stop the activities of developing this until a new environmental impact assessment which takes into consideration proper public participation and the aspect of climate change is brought back. And the tribunal even went further to give guidance on how this can be done. they say that in terms of public participation, this project has to be advertised in all of the media, the daily medias in Kenya, so that as many people can have access to or can be able to participate effectively during the development of this project. But also I think the major challenge, and that's why in the newspapers in Kenya, for those of us who read the newspapers, the conclusion of the media was that the power plant was closed because I don't know how they're going to justify that element of climate change in a manner that they proved that it wouldn't have an adverse effect on the marine ecosystem of land, or even the climate in itself. So that's why most of the people concluded, especially the media, that this power plant was closed, effectively closed. So what are some of the challenges that judges face when cases come before them? Sometimes the legislation is not complete, and yet, on the other hand, there are some international treaties which a judge can use, or agreements. But some judges have argued that their system is monist in nature. Sorry, it's dualist in nature, and they cannot apply international treaties. But thankfully, in East Africa, most of the cases that I've surveyed, even where countries have been considered to be dualist, they've at least used international agreements as persuasive material in deciding their cases. Then there are some challenges which apply to actions challenging government activities. And one of the challenges that judges face is the standard of review. What amount of deference that a court can give to the decisions of government and its agencies. I'm grateful to the tribunal in Kenya that they went as far as they could in terms of determining that they can challenge the decisions of government agencies, especially where they are considered to be incomplete, can be challenged before tribunals and courts. But that's not what happens everywhere. Then there's the question of time frame. I'll explain this in as far as my court is concerned. The treaty establishing East African Court of Justice only gives a time frame of 2 months for any party to bring a case before a court. So if you are outside the 2 months limitation, then we have no choice but to throw out your case. So this is a big challenge where the time frame is very limiting. 2 months for me is very limiting. So some of the cases which would have found their way in the East African Court of Justice don't come to the court because just because of the time frame which is in the treaty. Then some cases in East Africa come in form of criminal prosecutions. I won't go in details of this because of the time challenges that we have. Then there are challenges of standing. Thanks God for the court where I am as a judge. Standing is broad enough. You only have to prove that you are a resident of East Africa in order to bring in case challenging any violation of the treaty, including environmental articles. Then there are questions of science in the court. This is a very big challenge in that part of the world where I come from. I think it's Antonio who earlier on said that when you're the petitioner, most of the times you are the weaker party, not only in terms of financial resources, but also the scientific knowledge. So there's obviously need for supporting this area in that part of the world, because I can see many cases being rejected because the science before the court is not convincing enough, or even where you have scientists from the universities around. They don't know how to communicate the science in a language which the judge will understand. So that's a challenge which ought to be dealt with in that part of the world. Then finally, I want to talk about a point which is very important in that part of the world. You'll find that there are some companies which come and incorporate in many of the African countries, including those in East Africa. But they incorporate in such a way that if you try to bring a case against them, you won't have effective remedy. So there's a corporate veil, that's the term which is used. And these are multinational companies which undertake these big projects. A very interesting case is one which took place in Zambia. A big company was involved in mining of copper. And, through its activities, it polluted the river in Zambia, I think it was Goa. But the parties there could not bring an effective case in the Zambian court. So they went to the UK courts because the mother company was incorporated in the UK. Thanks to one of the Brussels regulations, which provides that a judge in the whole of the European Union cannot reject a case on the basis of forum non-convenience. So the courts in the UK, both the High Court and the Court of Appeal, agreed that they cannot entertain this case, which involved pollution in Zambia. So this is in my view, I think a very good regulation, which is a Brussels regulation, which is binding on all the EU partner states. So you can bring a case where you can get effective remedy if you think that you cannot get effective remedy where a given action has led to pollution. Then there are certain legal principles which we've talked about in different declarations, such as the 2016 IUCN World Declaration on the Environmental Rule of Law, the principle of in dubio pro natura. Even though this principle has not been stated as such in many judgments in Africa, you can see that judges have implicitly applied this principle. In the Serengeti case that we had, it was before 2016, so we hadn't quite known how to frame this principle that we were going to use at the appellate division. Anyway, the outcome of it seemed as if they're using the principle of in dubio pro natura, which simply means that if, as a judge, you are faced with a case and you still have doubts, the doubts should be in favor of nature. And I think this is where the judges in Africa head into when you look at it, which is growing today. I think by and large that's the broad picture that I wanted to share with you, given the time limitations that I have. But I do believe that, in conclusion, that all of us judges operate within territorial boundaries defined by rules of each jurisdiction. Obviously, we have our own distinct history, culture, and constitutional treaty arrangements. So we have to take into consideration those arrangements that we have because of the legal framework that we work within. But I do believe that there is quite a lot that we share in common, and we can learn from each other, and we can try as much as we can to see where the boundaries of the laws can end. But you can only do that if you interact in fora such as this. And I'm very glad that we as judges have started this. We've started this conversation, and I look forward to more of these conversations. Thank you very much.
Wow, we're here. Aloha.
Aloha.
First of all, I would like to recognize and thank Chief Justice Rectenwald for his leadership on the Supreme Court of Hawaii, as well as the University of Hawaii and the School of Law represented here by Denise Santolini. Without them, this would have not been possible. I also want to especially recognize my colleagues, friends from many years in the organizing committee, Justice Mike Wilson, Professor Denise Santolini, Arnold Grell, who were represented here by Andy Ryan from UNEP, Scott Fulton, Justice Benjamin, because I'm just honored, humbled of the privilege and grateful for the opportunity and privilege of working with all of you and getting to know you and learning from each and one of you every day. You have been friends, mentors, very significant in my career. And I also want to thank all of you for making this important milestone in the environmental rule of law possible, especially the students, because you are the future. You are who we are looking at to make the environmental rule of law a reality. That said, I have been asked to share some regional perspectives on the role of judiciaries in the environmental rule of law and the future. What I will share with you is informed by years of work on environmental law, justice, and security in 34 countries of the Americas. However, I would like to begin very locally and speaking about change. As I was growing up in an island in the Caribbean, the Dominican Republic, one of the most mega diverse countries of our region, I witnessed crabs crossing the road, numerous sea turtles swimming very close to the shore, sardines, a bountiful ocean. My children's experience when they visit my country has been rather different. They have to go on search expeditions in an attempt to verify if their mother's stories are real, or to try to sample some of what once was. This, for me, illustrates change and how rapidly it is occurring in just one generation. In light of this change, the law is meant to respond. I wish it were to prevent rather than to try to repair. As we all know, the current scenario that we have is more than 1 million species endangered or in risk of being endangered. And a lot of those species are unfortunately from the Americas. We have visible impacts of climate change on water security, extreme events, and very clear ecosystem change. And this translates in the more than 1,600 social and environmental conflicts that we have in the Americas. And that is without accounting the numerous investor-state disputes that are being brought in arbitration mechanisms, in financial institutions, challenging the authority of governments to protect their environment, their discretion to rule in favor of public interest. So in that scenario, what is happening is both that we need to, and judges specifically, are working to prevent, attempt to repair, protect, and defend. This kind of change that I've been speaking about has brought up a niche for judicial response. Given the progression in the ecological crisis, the judiciaries in the Americas have dabbled in a quest for answers that enable the fulfillment of their constitutional duty to protect the environment, reacting in the face of risk, imminent danger, and uncertainty, non-traditional threats to the security of states, the elephant in the room mentioned by Justice Benjamin this morning, climate change. Or judiciaries have become the last bastion, the final frontier. In addition to solving social and environmental conflicts, judicial decisions have become an educational tool that allow judges to serve as agents of behavior change in society in the face of new threats. The Organization of American States, where I, until recently, spent a large part of my career, supported judicial branches of the Americas on the basis that justice and security are the true foundations for peace. These efforts entailed capacity building and specialization on environmental issues of judges, exchange of experiences, and the designation or working with key allies, environmental justice goodwill ambassadors from Argentina, Brazil, Chile, Mexico, and Peru. 3 of them are here today, and I also want to pay tribute to them because, to speak in environmental terms, they are some of the finest specimens of their kind, and it is really a privilege to have them in our army. These efforts also entail the facilitation of jurisprudential dialogue amongst justice operators, meaning prosecutors, administrative authorities, anybody that has something to do with the chain of developing and implementing environmental law. Jurisprudence in countries of the region show a trend in the consolidation of principles of law and criteria on issues such as the right of nature. For example, this morning we heard the Chief Justice of the U.S. Virgin Islands refer to one of the cases in Colombia where the rights of a river were established. And this is not the only case. We have about 3 or 4 cases in the region, 2 in Colombia. We have the case of the rights of the Amazon that has also been mentioned, and the judges as well on a very important principle, which is intergenerational equity and the rights of future generation, where we have 25 younglings, as I call them, in ages between 7 and 25, demanding action on climate change, and the court has decided that an intergenerational plan on climate change needs to be enacted by the government. Other principles and criteria that have been established have to do with something that has also been mentioned today, the link between human rights and the environment. But not only because of a connection, meaning that the right to life will depend on the right to a healthy environment, but the connection of human rights and the environment on its own merit. Having the right to a healthy environment is something that we are all entitled to, and human rights obligations take place in a system of environmental conventionality, meaning within the context of all the MEAs that have been signed and ratified by member states. And this has also been said and taken further by the Supreme Court of Argentina in a very recent case. The principle of non-regression. We have a case from the Constitutional Court of Brazil, Parque Campos da Amazônia. In this case, the court established that you can't alter or change the limits of a protected area by a provisionary or decision from the executive, that it's required that a law be enacted with ample and broad discussion and participation from the public, which brings me to Principle 10. Environmental decisions are best taken with the participation of those that are interested and that could be affected. Another very important principle that has been established in the region and built upon is the principle of the social and ecological function of property. We have cases in Brazil about this, and a very important case in Mexico, the state of Quintana Roo, where the Supreme Court established that it is possible to limit property rights to respect the ecological and social function that property should have. This was a case of a tourism development and wetlands that were protected under the Ramsar Convention. We also have the precautionary principle. A recent case in Chile with regards to an industrial park that has been in place for many years, and there were plans to expand it and install a thermoelectrical central. And in this case, there were more than 1,000 victims of environmental pollution. And the court established that even though some of those pollutants were not even regulated, were unknown, and there was not scientific certainty about what the consequences of being exposed to them were, the evidence was clear. There were people that were affected and that were sick being close to this. And applying the precautionary principle, the court decided to temporarily and finally permanently close this facility. This shows the power of environmental law in the context that is not a legal discipline of damages. It's a precautionary, it's a law of prevention, as I would call it in Spanish, and it also shows the power of injunctive measures and using the tools that all judges have at their avail, like experts, intervention by third parties, and using different precedents. Through these decisions, judges in the Americas are closing the gap between law and implementation. Judges have built bridges through their significant contribution to the development of the sources of international law. Key examples of this include the significant numerous contribution of judges from the region to the Brasilia Declaration on Water Justice. Also, the environmental sustainability principles for adjudication adopted by the Ibero-American Judicial Summit, drafted with the help of many partners, including the Judiciary of Chile and the OEA's Goodwill Ambassadors, some of which are here, as I have mentioned. In the Americas, recent decisions also show the value of the progressive implementation of these sources of international law, using elements of different legal disciplines, preventing the evolution of environmental risk or damage, managing numerous uncertainties for which the precautionary principle, as I have mentioned, is key. Judges of the Americas, indeed, have been adjudicating on future. Difficulties are meant to rouse, not discourage. The protection of habitats in a mega-diverse region like ours is the only guarantee of species and our own survival. I don't have to tell you about the very strong interest evidenced in all of the environmental conflicts, and particularly in the ones that I have mentioned are occurring in the region. This interest can only be balanced by the gavel of justice. Jurisprudential dialogue and judicial action in the protection of our home is a moral imperative of Kona. Righteousness and balance, and must deliver beyond hope. Albert Einstein said that there are two ways to live: as if nothing is a miracle, or as if everything is a miracle. Is the fabric of life, billions of years in the making, or home, or ohana, a miracle? In closing, I would like to leave you all to reflect on our choices. Thank you. Mahalo nui loa.
Colleagues, my name is Andy Rain. I am with the United Nations Environment Programme. For those of you unfamiliar with UNEP, we are based in Nairobi. We're the only UN agency that has its headquarters in the Global South and in Africa, so we're quite proud of that. I think I have the best job in the world. I have the best job in the world for many reasons. One, I get to come to beautiful places like this in Hawaii, and I'm very grateful to Justice Wilson and all of the team behind this conference. I know it's always more than just a small group. It's everyone working to make it a success, and I'm really, really grateful for that. But importantly, I think I have the best job in the world because I get to work on a topic that I am deeply passionate about, environmental rule of law. And I see my role at the UN as doing everything we can to put oxygen into this principle, to put everything we can do to make this new principle a success. And that's why we are very proud to be a partner to the Global Judicial Institute on the environment, and a partner to many of you in various forums. When I look around this room, I feel jet-lagged because I've been to, I counted in the break, about 30 countries amongst us in this room, and we have done a lot together, but there is so much more to do. It's a journey that could probably be best described as a quest, because in a quest there's lots of dangers and there's many dragons to slay in this quest. At the World Economic Forum in Davos, our Secretary General speaks about the 4 horsemen of the apocalypse. Climate change, climate crisis is the first. Inequalities is the second. Mistrust, this brewing political mistrust. And then finally, misinformation. And all of those are real and present dangers to this quest we find ourselves in advancing environmental rule of law. But, on a more optimistic note, what a great time to be pushing forward this agenda. 2020 is commonly referred to as the super year, or as Denise calls it, the start of the super decade. And the jet lag will continue because we all en masse go to Rio, where we will really put a lot of oxygen into environmental rule of law. Then we travel to Kunming for the Biodiversity Convention, which will set the new global biodiversity agenda for the next 10 years. And then finally to Glasgow for the climate COP. So it's all happening in this year, and you are the key stakeholders to make it happen. So very privileged to be here with you. Now, I'm not speaking, I'm just a co-chair, so I better shut up and introduce our wonderful panel. I see this session, Environmental Rule of Law, Emerging Trends and Principles, as the engine room of this whole conference, so we really want to get into it. My co-chair is a bit of a superstar, Julia Olson. She needs no introduction, and we're taking the liberty of, instead of making her just chair the panel, we want to give her some space to tell her remarkable story, just for a few minutes, to take that opportunity and not lose it. After Julia's spoken, we've got 4 or 5 speakers. I'm not as soft and cuddly as Denise when it comes to timekeeping, so I'm going to stick you to it. So I think we've got 10 minutes for each speaker. We can stretch it to 15 if absolutely necessary. We've entrusted our fierce Y1, is that what we call ourselves? 1Y. This is a foreign concept to an Australian. We use full words and sentences in Australia. Our 1Y will keep you to time. So please do not take it as a sign of rudeness, just as a sign of efficiency, because we are running behind time. So without further ado, let me first invite Julia to come and tell your story. And thank you very much.
Good afternoon, everyone. It's a pleasure to be here. And I want to especially thank Denise, who is not here, but Justice Wilson for inviting me, and for everyone who helped organize this incredibly illustrious group of judges and experts from all over the world. And I too feel like a little bit of a different breed here because I'm a litigator, and I try to bring these cases carefully crafted about climate change on behalf of children to judges around the United States and around the world to hold governments accountable for protecting their basic human rights that are embedded in constitutions around the world And we also use the public trust doctrine, which has a great body of law here in the state of Hawaii, actually. I just want to thank the students. So we rely a lot on students, and I think the energy and work you bring to law schools, and then when you go and clerk for judges, and how you can help educate them on these issues is vital. So thank you for being here too. As an attorney for children, I think I have one of the hardest roles to really bring their cases forward in a way that allows judges to have the courage to step into this space of really being those neutral arbiters, but also being the defenders of justice and human rights on behalf of children. And some of you may know we had a setback a couple of weeks ago in a decision that came out of the Ninth Circuit Court of Appeals in our Juliana versus the United States case, which is one of our seminal cases that I work on. And I just want to briefly tell you about that ruling, which found that 21 children did not have standing to bring a constitutional claim in federal court under the substantive due process and equal protection clauses of the U.S. Constitution. And I'll tell you why they made that finding in a moment, but I was remarking or considering the remarks of Justice Antonio Benjamin this morning. And where are you? There you are. So you said that the U.S. Constitution doesn't have the word environment in it, but it does have the word life, and it does have the words our posterity. And really, even the founding fathers of the United States understood that the foundation of life was the air and the water and the seas and the shores of the sea and the wildlife and the forests. And they knew that natural wealth would build a nation. And I have this quote I wanted to show you, and it's from James Madison in 1818. And one of our founding fathers, who wrote the Fifth Amendment to the U.S. Constitution, said in a speech in 1818 that the atmosphere is the breath of life, without which they all perish. And those men were farmers. They understood climate. They understood the importance of the soils and the air and the watershed. So they didn't have to write the word environment in the U.S. Constitution because the Constitution was written on that public trust for the people. So that's sort of the bedrock of the Juliana litigation. The standing decision was based on the redressability prong of standing. So for those who aren't familiar with standing law in the U.S., we have to show that our plaintiffs have been injured, that the injury was caused by the defendant, and that there can be a remedy. And it doesn't have to be a whole remedy, but some partial remedy. And the Court of Appeals found we met the injury in fact prong, that we showed that the federal government of the United States is a substantial factor in causing climate change, but that the court can't do anything about it because the problem is too vast. And so we'll be appealing that decision. But I also want to just reflect on two more comments from this morning, and then I'll turn it over. One was from the Chief Justice from Argentina, Lorenzetti. You're still here. You talked about the need for a systemic response and for paradigm shifts. And I think that's really, really important. And Judge Kobayashi this morning also talked about how technological changes have threatened our rights to privacy in new ways. And that the courts have to respond to the new science and the new technology that threatens us in ways we didn't understand before or couldn't have predicted. And I just want to take everyone back to a different time to look at a different paradigm shift and a systemic response. And that's 1954 in Brown versus the Board of Education. Another seminal case in the U.S. about the rights of children. Children who couldn't vote, but went to court. And in a declaratory judgment from the U.S. Supreme Court, the court said that segregation was unconstitutional. It wasn't for another year that the court then ordered the desegregation plans that have been carried out in the United States ever since. And courts to this day retain jurisdiction over these cases to desegregate public schools and facilities. So I draw inspiration from that movement, another time of great harm to people and to children, and the courts stepped in, and we would not be the country we are today without that kind of judicial courage. And so thank you so much for being here. It's an honor to listen to all of you.
Aloha. I was about to begin this 10-minute second intervention with a complaint against Denise, Professor Antonelli. Is she here?
She's working.
Let her have it. Because I thought, why me speaking twice? This extra work and stress. I thought that I was a victim. Perhaps I'm a victim, but I'm not the only one, because Chief Justice Ryder, I noticed he's also speaking twice. So I feel
After you.
not
That is double.
I noticed some irony in this comment. That he's concerned with his time. No, I will speak for 10 minutes. I believe the organizers invited me to speak twice, because on this theme, we are, on this session, in this session, we are discussing environmental law principles, and my court has been a pioneer in developing some of those principles extensively. I will begin, though, with a note, perhaps a footnote, in respect to something that Chief Justice Ryder mentioned this morning, that one of the benefits of being together in an event like this is to exchange experience and see how different countries sometimes are dealing with the same types of issues. And in the environmental arena, this is so common, through different avenues, sometimes reaching very good and similar conclusions, sometimes reaching conclusions that are completely different. And Julia, one of the cases that I would, in this footnote, and the case that I'm going to mention, has to do with what you just said about the U.S. Constitution. And I totally agree with the Constitution that protects life, protects the foundations. It would be absurd to imagine that we would protect what comes, something we call life, but not what generates and make it possible for life to flourish in our planet. And the example is with the Constitution of Pakistan. It's one of the very few constitutions in the world that doesn't have doesn't recognize the environment and a right to a clean and safe environment. But the Supreme Court of Pakistan, many years ago, it was not yesterday, came to an opposite conclusion of what other courts, and I'm not talking about the United States, obviously, would reach. So, in Pakistan, the court held precisely that. Our Constitution protects life. And because it protects life, it has to protect the environment. So it's here. So just a footnote in this comparative exchange that my colleague Paul Ryder alluded in his intervention. About environmental law principles. I think it would be interesting to begin destroying, it's not a nice word, but demystifying one myth that we have in comparative law. That in common law, you have judges that can be more creative, judges that can, through precedents, basically design the legal system. And in civil law, it's just the legislators. But if we look around, two conclusions immediately arise. First, that in those countries that theoretically the judge would have more freedom, we see nowadays the opposite. The judges that are asked to go against the fundamental principles, not of law, but of ethics. And law has to be structured on over ethics. So this is very serious. And on the other hand, we, civil law, Ricardo Lorenzetti and me, Alfredo and others, we that were supposed to be under this very tight shirt, just following what the legislators do, we go beyond that, and not because we are making new laws, but because we use a technique that is 100% judicial, legal principles. So legal principles is directly associated with the core role of judges. And it's here that we see nowadays a huge expansion of legal thinking about the environment. Claudia Windt, is she here? Oh, there she is, in her excellent presentation, already listed some of those emerging legal principles. In my 4 minutes left, I will just emphasize 3 of those, not repeating Claudia, and asking Nick Bryna, Professor Nicholas Bryna is here. There he is. Tomorrow he's chairing a session to say something more. You are chair, so you can manage the time. To say something more on the indubio pro natura principle that is really expanding globally. And Professor Bryna has written a wonderful piece, comparative piece on this principle. So the 3 principles that I would like to just to repeat somehow what Claudia Windt has just said are first the ecological function to property rights. We, in a number of constitutions, have this clearly or not so clearly stated, but the courts have read the whole mosaic of the legal system and come to the conclusion that in addition to the social function of property rights, we also have now an ecological function to property rights. And this has immense repercussions in everything that we do, because environmental law is basically a legal discipline to address the failures of property law. And if we don't have a principle to work with, then we'll be working on a piecemeal approach without the coherence, the theoretical coherence that the ecological function of property rights do grant us. 1 minute to the to each one of the other 2. A principle that Claudia didn't allude to, perhaps because she was short of time, is the what we have called the principle of the Procter nature of environmental obligations. Both in common law and civil law, we are used to classifying obligations into two different families, and with one in the middle that we don't talk much about, not even in law school. So real obligations dealing with things, property, and personal obligations. But there is something that was developed in the Middle Age called Procter. So it's a type of obligation that is in between. And it's in between because it's related to people, but at the same time it's attached to the real object, to the land, for example. And if you sell the land, you are selling not just with the rights, like a mortgage, you are selling as well those obligations that are attached to the land. And this is absolutely fundamental in countries that have massive deforestation. Because the first argument of the defendant is that your honor, two arguments, it was not me. I bought it, it was already illegally cleared. I knew it, but it was not me, causation. Or the other argument in your honor, in fact I did it, I hate forests, but your honor, I did this 30 years ago. They statute of limitations. So it's tremendously important. And someone this morning, I think our colleague Kobayashi mentioned the change in legal paradigm. This is one of those change in legal paradigm because it solves a number of problems that we have, and this is something developed by laws, by judge, but not just out of the blue, inventing the wheel. This is part of our legal system. And my final, and I am within the framework of my time, so Paul, don't complain. The third principle that I wanted to allude is the one that I'm challenging Nick tomorrow to say more about, which is the individual pro natura principle. We talk everywhere about the precautionary principle. And when editing the video, caught what I'm going to say now. We judges don't understand it. Perhaps just the Germans. It comes from Germany. It's now an international principle. It comes from Germany. And we don't understand because the title, the name, but also the formulation is too complex for us. But we do understand in all jurisdictions, first-year law students, inmates in prisons, they do know the indubio pro reo principle. In case of doubt, in favor of that, of the defendant. And that's the beauty of the indubio pro natura principle. If you have 3, 4 different possibilities of construction of a rule, a constitutional provision, make sure that you judge, analyze all of them, you rank them, and not in all circumstances, you take the one that better protects the environment, if it's an environmental tax, because environmental taxes are supposed, the rationale is to protect the environment. But there is also another side of the indubio pro natura principle, which is in evidence, in burden of proof. And this is the more pragmatic aspect of it. So, in conclusion, we keep talking about the traditional principles of environmental law, the principle of prevention, the polluter pays principle, and several of those principles were invented where? In this country. Americans tend to forget that in respect to environmental law, you are the Romans of modern time. Please don't forget. In the backsliding that we see sometimes, don't forget that you invented environmental law. And not just the instruments, protected areas, environmental impact assessment, I could name a number of them, citizen suits, but also the legal framework for that. That's an American invention. Didn't come from anywhere in the world. We borrowed it. So, in addition to all those traditional principles, the precautionary principle, and so on, we are seeing those new, evolving, emerging principles that are much more powerful because they have direct impact in litigation. So I do hope I spoke for 11 minutes, 11, almost 12. But you are so generous, and Paul, you are so generous that I'm sure I'm going to forgive you. Many thanks.
Aloha and good afternoon, everyone. During the lunch recess, I inquired as to the amount of time that was allotted for these presentations. Initially, I was told 15 minutes, so I prepared a 14-minute presentation. During the lunch hour, I was told if I could go maybe up to 20 minutes, so I made adjustments for that. And just a few minutes ago, I was trying to make adjustments to get down to 10 minutes. So, I don't know, so this may sound interesting even to me. At any rate, my name is Joe Cardoza, and it's certainly a privilege to be here and speak to all of you today. I'm a retired Second Circuit Court judge from the island of Maui, and I was fortunate enough to be among the first group of environmental court judges in Hawaii. I've been asked to share my thoughts on the statewide environmental court system in Hawaii. It might help if I begin with acquainting you with my home. The Second Judicial Circuit includes 3 populated islands, Maui, Molokai, and Lanai. Each island is quite unique. Maui is the most populated island, and it was very much an agricultural community for a long time. Today, its chief economic engine is tourism. The economy is strong and unemployment is very low. However, the cost of living is extremely high. South and West Maui are resort areas and also have very strong local populations. On a daily basis, the major highway to West Maui is hit by ocean waves. That obviously is a problem that's going to have to be addressed. Molokai has a much smaller population, and many on Molokai prefer to maintain the old lifestyle with no development, choosing to live off of the land and the sea. Unemployment is typically high, but their preservation of the time long gone by is remarkable. Lanai has the smallest population. 97 to 98% of the island is owned by one person. Today, Lanai's primary resort is primarily a resort destination. It was once very heavy in agriculture. But its major landowner has reportedly expressed an interest of flying from Lanai, a type of drone that is the size of a football field, for research purposes. Why do I mention this? Because these are unique communities that present very different needs and therefore varying and sometimes competing environmental concerns. Thus the need for an environmental court. I am sure it is no different throughout the world. Our environmental court commenced operating on July 1st, 2015. Within the first 15 minutes of its beginning, the first Circuit Court environmental case was filed in the Second Circuit. The case sought to end sugarcane burning on Maui. As an agricultural crop, sugarcane was clearly the largest crop. For over a century, Maui had been the site of a very large sugar plantations. The most cost-effective method of harvesting sugarcane is to first burn the leaves off of the cane stalk. This, of course, gave rise to a number of environmental issues. Ultimately, the suit was settled with the last remaining sugar company on the island, which already had been struggling financially, agreeing to cease operations And of course that resulted in the loss of jobs for approximately 600 people. This was a dramatic change for the island of Maui and a challenging start for the environmental court. The sugar plantation land has been sold and is slowly being used for diversified agriculture. Since the filing of that first environmental court case on Maui, the Second Circuit has remained extremely active with many different environmental court cases in the criminal as well as in the civil arenas. Our environmental courts have exclusive original jurisdiction over all proceedings relating to many areas, including drinking water, air and water pollution, historic preservation, water and land development, forest reserves, wildlife, fishing rights, commercial fishing, aquatic life, conservation and resource enforcement, and the environmental review process. The Hawaii Constitution provides an important framework for our environmental law, and it is significant to note that in part it provides that for the benefit of present and future generations, the state shall conserve and protect Hawaii's natural beauty and all natural resources, including land, water, air, minerals, and energy sources, and shall promote the development and utilization of these resources in a manner consistent with the conservation and in furtherance of the self-sufficiency of the state. All public natural resources are held in trust by the state for the benefit of the people. And that provision says a great deal. And the Constitution also provides that any person may enforce the right of environmental quality against any party, public or private, through appropriate legal proceedings, subject to reasonable limitations and regulation as provided for by law. And so we have a framework here that's extremely important in the state of Hawaii that establishes environmental courts and also provides an extremely important framework for judges to rule on these cases and to consider the various concerns and issues that come before the court. I have some observations with respect to the environmental court. First, one of the questions that was asked when environmental courts were first discussed was whether we really even needed them. It was said that environmental court cases would be heard by the same judges in the same courtrooms throughout the state. However, that is really not the way our environmental courts operate. Only certain judges are designated as environmental court judges. The court has exclusive and original jurisdiction over the areas that I've just discussed. Environmental court judges attend specialized training before and during their service as environmental court judges. Specialty courts provide these benefits. In my experience with specialty courts in the environmental court area, as well as in several other areas, leads me to the conclusion that environmental courts provide better guidance in terms of specialty courts and environmental courts in particular. That provides far better guidance for all of us, including the community. And if an individual in the community is planning an action that may be subject to our environmental laws, the more developed the body of law is, and the environmental courts is creating this, the better off all of us are for that. I also have found that ancient conservation practices are extremely significant. It is often said that the Hawaiian archipelago is the most isolated landmass in the world. Ancient Hawaiians fed a very large population through appropriate use of natural resources. There were no ships or planes bringing goods to the islands. They had to live in harmony with their surroundings. They found a way to do so. Often it was not a matter of choice, it was a matter of survival. Perhaps we will be facing similar challenges as we move forward in the history of this planet. And I think we can learn a lot from those that preceded us many, many centuries ago. Another observation that I would share with you is that, and I think this was touched upon this morning, and that is in the area of litigation in this area. My own observation is that it's important for all of us to understand that to me, an environmental court, there really aren't victories. There should be justice, and it should be fair for all concerned. Whether a plaintiff or defendant prevailing in an environmental court case may obviously create a significant impact on the lives of others or a community. There is no legal requirement to do this, but would compassion and problem solving on the part of a prevailing party better serve all concerned, including the environmental court? My inclination is the answer to that question is in the affirmative. It would be best for us to always look for solutions that, if we prevail in an environmental court case, that produces something that, a product that benefits all concerned. Now I have a question, and that relates to the settlement of environmental court cases. And here's the question. What, if anything, is the role of a court when an environmental court case settles? For example, what if a case is brought by a private party or an organization that raises substantial issues concerning the impact of an action on the general public? For example, water, air, matters of that nature. Assume a cash settlement is entered into between the parties to that environmental court case that does not address the issue that may impact the general public. If there is no provision of law that requires the court to approve the settlement, does the court simply dismiss the case, or should the court be concerned with the terms of the settlement and its impact on the general public? Because there are environmental court cases that arise that do raise serious issues related to the general public. And settling parties may or may not address those issues in their settlement. What are we left with then after that occurs? What if it involves an aquifer? What if it involves air quality? What do we do with that? And that is a question, I don't have an answer for it, but it's a question that has troubled me as an environmental court judge. Now, in concluding, I didn't see the sign yet, so, but you did. Okay. In concluding, Hawaii Supreme Court Associate Justice Michael Wilson often quotes me as saying that the establishment of the Hawaii Environmental Court was historic. I said this because it seems clear to me that with each passing year, new and difficult environmental issues arise. I spoke to someone a couple of years ago from Yap who talked to me about the fact that half of their islands are now submerged underwater, and how difficult it is for him to realize that his ancestors are buried in one of those islands that is now submerged by water, and to to face the reality that his people will have to relocate. How are we going to handle those issues? What happens to those people? How do we integrate them into our society? These are all related to environmental law, and these are extremely difficult issues. Some of these problems, in my view, will require the wisdom of Solomon and the intellect of Einstein. I am relieved that in 2015, our state embarked on the journey of examining these difficult environmental issues and creating a body of law that is fair to all concerned. Greater challenges are no doubt approaching. All branches of government will need to work tirelessly to address these difficult issues. The judicial branch of government will need to develop, or continue to develop, the environmental rule of law for present and future generations. With environmental courts, the future is challenging, but in my view, encouraging. In preparing these remarks, I came across something that was written in 1931. Again, written in 1931. It read, "There are many men now living who were in the habit of using the age-old expression, it is as impossible as flying. Well over a century ago, most believed that human flight was impossible. There are some who believe that environmental justice is either unnecessary or impossible to achieve. I am encouraged because I know that with the commitment and expertise gathered in this room today and throughout the world, establishing an environmental rule of law that is fair and beneficial to all concerned is indeed possible. Mahalo and aloha.
Let me offer a heartfelt aloha.
Aloha.
I'm Mary Kay Lyncham, one of the judges on EPA's Environmental Appeals Board, and I'm here with my colleague, Judge Kathy Stein, and we're going to share our 10 to 14 minutes, try to make it on the shorter side. But we were remarking how perfect Hawaiʻi is for this particular symposium. This morning, Justice Benjamin was talking about Pachamama and Mother Earth, and she's right outside in all her glory. You know, at lunch we saw the incredible banyan trees. Last night we saw the Pacific. But I'll tell you, I find it somewhat bittersweet because it reminds me of what we've lost in other parts of the world, including in my own neighborhood right outside of Washington, D.C., just the removal of 100-year-old oak trees. But I also feel incredibly inspired after today's discussion. And that's why Judge Stein and I really felt that it was so important that we participate in this conference and offer our support in applying the rule of law to the environmental challenges that we've been talking about. And I know that many of you are familiar with the EPA's Environmental Appeals Board, but let me briefly describe it to the rest of you. And I would like to note that this year is EPA's 50th anniversary. Apparently the same year as Scott Fulton was born. Perhaps I misunderstood. But a mere 28 years ago, EPA established the Environmental Appeals Board. It was established in 1992 by regulation, and the idea was to establish an independent, specialized tribunal to adjudicate environmental disputes with the full input of various parties and the public. And we focus primarily on resolving disputes about federally issued permits and federal administrative enforcement actions. And today we're going to focus on enforcement actions, and in particular the enforcement of financial assurance requirements as a key component of applying the rule of law. And Scott described the concept and the definition of the rule of law this morning, and I won't repeat that, but recall that it included a strong accountability mechanism, including a robust enforcement mechanism. And what Judge Stein and I have found at EPA is that the enforcement of these financial assurance mechanisms by which a company is obligated to set aside funds at the beginning of their operation to clean up any damage to be a key component in actually preventing pollution and then, of course, remediating it. And we found that the financial assurance mechanisms actually promote financial sustainability and environmental sustainability. The two things are tied together. And I personally think it was noteworthy that climate change was at the top of the agenda at the recent meeting in Davos of the World Economic Forum. So in terms of our practice, a number of the U.S. environmental laws require that owners and operators of hazardous waste facilities and underground storage tanks provide financial assurance that you pay for cleanup needed and compensate for any harm that's caused by future contamination. And without these requirements, what we've seen is that the burden falls on the public And the data shows that it falls disproportionately on low-income and minority populations. And for years, there was a lack of compliance with these requirements, and frankly, a lack of enforcement. And we saw the incredible damage that left in these communities. So an example of one of the laws that has these requirements is one of our hazardous waste laws, the Resource Conservation and Recovery Act, also known by the acronym RCRA, but you don't have to remember that one out. And it has two different types of financial assurance requirements. And one type of financial assurance requirement address known costs for what we call closure and post-closure care. So for example, landfills are subject to financial assurance requirements to ensure that the funds are available at the end of the life cycle of the landfill for an environmentally sound closure of that landfill. And a second type of financial assurance requirement is for potential property damage and bodily injury to third parties from accidental sudden and non-sudden occurrences. So in other words, for costs that are not known at the beginning of the operation. And the amounts of financial assurance required are based on cost estimates by third parties, and they have to be updated annually to account for inflation. And there are 6 basic types of financial assurance mechanisms. And some of these are immediately available to access, even in the event of bankruptcy. So there's trust funds, surety bonds, letters of credit, insurance, a financial test and corporate guarantee, and then a combination of all of the above. And each of these have very specific requirements. So now Judge Stein is going to briefly discuss 2 cases of noncompliance and the board decisions that emphasize the importance of this requirement and its application of the rule of law.
Thank you. I'm going to talk about 2 cases that the board decided. They're actually not recent cases. One we decided, I was the lead judge on that in 2008, and the other we decided in 1997. However, these cases have resonance today. I think they're critically important, not just in the United States setting, but in an international setting as well. And I was reminded by Chief Justice Hodges' remarks this morning when he talked about the importance of insurance. He was perhaps talking about personal insurance, but this kind of insurance is insurance for the benefit of the public at large. In addition, Judge Lynch and I did some work in Vietnam a couple of years ago with their Ministry of Natural Resources and the Environment. And one of the major topics they wanted to talk about was financial assurance. They had had a major incident involving, I believe, Formosa Plastics that had adversely affected the fishing community, and they didn't have the mechanisms in place that they wanted, and they were getting experts in Switzerland and all over the world to come talk to them about financial assurance. So the first case I'm going to mention is called Euclid, and this involved 23 facilities owned or operated by Euclid in 3 states, Maryland, the District of Columbia, and Virginia. And our board upheld a penalty of more than $3 million for all of the violations of which the financial responsibility provisions were just a piece. But Euclid was charged with violating 7 different requirements in the District of Columbia, and Euclid came in and said, I have insurance. Well, guess what? We didn't think they did. They claimed that they had insurance because they had self-insurance. They were self-insured, but they were relying on some of their affiliates to provide the insurance. But there were no formal guarantees. No trust fund had ever been set up. No documents had been filed with the local District of Columbia. So essentially, it was a false guarantee. There really was nothing there. The ALJ ruled against them on that point. tested our board. Similarly, Euclid was saying that they could self-insure because they had plenty of money. But they had unaudited financial statements, and they had nothing filed with the Securities and Exchange Commission. So they had done nothing to implement the very detailed requirements in the regulations so that there really would be money there in the event of a problem. As a result of this lack of verification, we upheld the ALJ's assessment of a substantial penalty, and we rejected the company's claims that their penalty should be reduced because they thought they had insurance. It wasn't a particularly credible claim, and as the board noted in its decision, the company had been previously fined and cited in the state of Maryland for financial responsibility requirements as well. So that was the Euclid case. The second case is Harman Electronics, which was reversed on other grounds that are completely unrelated to what I'm going to talk about. But this was a case of the RCRA hazardous waste violations. And it involved a company's failure to establish and maintain financial assurance for closure and post-closure, and liability coverage for sudden and non-sudden accidental occurrences at landfill. In its decision, the board noted how important these requirements were to the Congress, who had required EPA to promulgate regulations to assure there was financial responsibility, all of which contemplated an ongoing availability of funds in the event that the owner was insolvent or unavailable. The Harman Company said, no, we're not operating anymore. We've closed our landfill. Therefore, we don't need to have any insurance. Relying on an established precedent from an earlier case, the board flatly rejected that contention, saying that liability must be maintained, liability insurance, until the closure of the facility is certified. We emphasized that the goals of the Resource Conservation and Recovery Act will not be fulfilled if the owner or operator does not have the financial wherewithal to achieve closure or compensate persons who have been harmed by the facility. The board upheld the assessment of over $250,000 for those violations, including a 25% increase for the bad faith of the company. So while these cases were decided a long time ago, I'm sure those of you who have been watching the hurricanes and all of the other weather events that we've had around the world can understand how these kinds of mechanisms, which in our case are imposed through regulations, become really important. And it's important that they're not just paper exercises, because when you have a problem, the last thing you want is discovering that the company that said they were worth millions of dollars was really not worth much at all. So the rule of law, in summary, provides the essential foundation for environmental laws to be effective. This includes accountability for everyone, including even-handed enforcement to level the playing field. One of the most important requirements for effectuating environmental accountability is assuring that funds are in place for cleanup and compensation in the event that an owner is unavailable or insolvent. And as this talk has illustrated, such enforcement can help and achieve financial and environmental sustainability. Thank you very much for the opportunity to be with you.
So I have cleanup, and I want to start by congratulating Julia, my pocket constitution. You're absolutely right. In the preamble, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. That's a wonderful passage, and I think it does ring true in the form in which you suggest. And in fact, we have a similar provision in our state constitution that says that frequent recurrence to fundamental principles and a firm adherence to justice, temperance, moderation, industry, and frugality are absolutely necessary to preserve the blessings of liberty, which is something that, in fact, our state has inscribed on a wall in the main foyer of the State House back in Vancouver. So I'm very impressed that you've got that in mind and that you're taking that with you. I have asked, I'm going to make a general comment, that this is about trends that we're talking about here this afternoon. And before I left Vermont, I asked a clerk for input about this, one of the young people in the office, who sent me a memo, and I'm going to read you Andrew's response. He identified 4 trends across this country, with some reflection on the international stage as well. 4 trends that exist here in America. The first being a federal retreat, as he called it, on environmental regulation, prompting significant pushback, he says, by the states. The second, legislation and litigation focused on chemicals called PFAS substances, some of you may be familiar with in drinking water. We have some of these cases in my state. The third is youth-led climate change action. And he wasn't just talking about your case. There are others that I'm sure you're aware of. And the last one was public nuisance and other tort actions brought by state and municipal governments against fossil fuel companies. I know many of you will be familiar with the case in New York City, heard by a state of New York Supreme Court judge, one of their trial level judges. I don't know if it was appealed, but it had to do with a claim against, I think, ExxonMobil in this regard. So those are the trends that Andrew mentioned. And what I'd like to do is consider with me a issue that I think all of these trends, maybe not all of them, but some of them at least, prompt me to think about, and that is the issue of politics involved in judicial operations, in the role of the judiciary, and the role of application of the rule of law. I did a survey last year for a speech I gave in Los Angeles at the Loyola Law School about judicial selection and retention across the country right now. It is very clear that the trend here is toward greater and greater influence by the political branches in judicial selection and retention. And there are a number of different places that you can identify where this is occurring, where legislatures have sought to take a much more aggressive role, if you will, in how judges are selected. In fact, in our neighboring state right now, in New Hampshire, a lot of people confuse Vermont and New Hampshire. I'm never offended by that, I want you to know. I don't care if you call my state New Hampshire, it's okay. I do, when I'm with them, I resent every single one of them. I don't let it go easily, that's my point. But, no, they're very similar states in a lot of respects, even the geographical shape. But right now, New Hampshire, the New Hampshire Supreme Court is sitting without a Chief Justice, and it has been since last August, when a good guy, a friend of mine, Bob Lynn, who was chief back then, retired under a mandatory provision in their Constitution, I think it's in their Constitution, of a mandatory 70 retirement. Under their system, there's something called the Governor's Council, which are 5 people who are popularly elected. The governor right now in New Hampshire is one of the Sununu's. Remember, there was a John Sununu, his father, who was, I think, chief of staff for Bush, maybe, I forget. But anyway, this is his son, who's governor of the state, who's Republican. And he appointed, and I actually was on a panel at the Dartmouth Medical Center last summer when this was in the offing, and everybody there, they were all on the inside. Dartmouth is in New Hampshire, and they were all on the inside of the, inside baseball. And they all said, oh, this guy's a shoo-in. He's the current Attorney General of the state of New Hampshire, and this is the fellow that Governor Sununu is going to appoint. Well, the Governor's Council voted him down. They did not approve him. Now, as a result of that, Governor Sununu, and I'm not casting aspersions on anybody here, let me make that clear. I don't have I'm not making a judgment about it. I'm just trying to describe what I see as the problem that exists right now in our nation, one of the problems. The governor has said that he will not appoint make another appointment to the chief seat until after the November election. He said this before the end of the last calendar year. You might can understand why. Everybody thought that the current Attorney General was a shoo-in, not because he was connected politically, but because for all I can understand, I don't know him, but for all I can understand, he's very well qualified. And he's very nonpartisan, even though he is associated with the Republican governor in some ways, apparently. So now the governor says, well, I'm not going to appoint. So they're sitting without a Chief Justice. It's not the end of the world. We saw it happen in Washington when President Obama sought to appoint Merrick Garland to the U.S. Supreme Court, and that seat was left vacant. My point is that there is tremendous evidence, not just in New Hampshire, not just in Washington, D.C., but across the country, of greater and greater desire on the part of the political branches to influence the operation of the judicial branch and the appointment and retention of judicial officers. In Iowa, here's one more example. In Iowa, this is a few years ago after the Iowa Supreme Court issued its decision on same-sex marriage. They had a retention vote. Under their system, they had a popular retention. They have popular retention of judges every so often, 6 years or something like that. So the electorate votes on that. But traditionally, historically, those votes, those elections, those retention elections have never been partisan. In 50, 60, 70 years, however long that method has been in place. Never partisan. Yet, right after this decision, hot decision, then probably wouldn't be as much now, I don't know, but a tremendous amount of money came into the state from out of state political sources in order to influence a nonpartisan retention election of sitting justices on the Iowa Supreme Court, and 3 of them, including the then chief, a woman named Marcia Curtis, who was very good, but got kicked out. So all I'm saying is that we are seeing evidence in this country right now of, I won't say influence, I'm not sure that I'm qualified to make that calculation, but I think it is quite clear that we see a greater and greater desire for the political branches in government to want to influence the operations of the judicial branch. And it's I think, a significant concern. And the reason I'm talking about it in this context is because I think this is the flavor that we see very often, not just in this country, but in nations around the world, at times of stress. At times of economic stress we've seen in South America, where historically, principles of checks and balances that everybody buys into, everybody agrees with, fundamental principles. And, we're here to make sure that the government operates in a wholesome way according to the original principles of the Constitution and the democracy. And so we're going to check what it is that you do. Well, in times of stress, economic stress, some other kind of cultural stress, I worry that people retreat. People in positions of authority begin to retreat, begin to relax from their otherwise attention to the ordinary details of what it is and the responsibilities for what they are supposed to be doing. That it's easier, hey, this is a really tough problem to solve for me, right? This is way too hard. There's too much baggage with this issue for me to have to make a decision. I'm going to let them do it, right? I'm going to let them do it. Oh, better yet, there's the president of it, there's the governor. Let him do it. He can do it. I don't need to do it. Let him do it. Let her do it. I don't want to take the heat in the press, wherever. And so my theme here with you is to say, we're at a time of stress in this world right now. I don't get it, really. I don't really understand it, but we were talking about this at lunch. You look around and there is divisive stuff going on all over the world, all around the world. A lot of it involves the courts. A lot of it involves judges. My point is, there's never been a more important time for us to keep our eye on the ball. This is our job. This is our responsibility. We are not, we don't have these roles to, dodge the tough questions, to not, be able and not be able with the science, right? People are talking about the science, it's so true. Not be willing to engage in the tough choices that have to be made. I'm very sobered by the times, to be honest with you. I really am. And I'm a glass half full kind of guy. Some days it's hard to see the water at the halfway mark. But coming here and being with you all, I will say is a terrific palliative to those thoughts. And it's really important, as I said this morning, that you all continue with your work and continue to maintain faith with desire to see these issues through a proper conclusion, to not lose that resolve, even in the face of circumstances that sometimes muddy the water in that glass. Okay, that's it. Thanks.
So I would like to start my short intervention with congratulating the organizers of the symposium. This is a very timely event that comes at a moment that global environmental challenges seems to become bigger every day. So I wish you a fruitful deliberation, and I am looking forward to the outcomes of the symposium. I was asked to update you on some recent developments of climate change litigation and law in Europe. I will try to do it in a short lapse of time, concentrating myself on the litigation part. And if we speak about litigation, climate change litigation in Europe, the most iconic case, of course, is the so-called Urgenda case, which is now final, following the Supreme Court of the Netherlands judgment of December 20 last year. So this case started with the District Court of The Hague. It's a civil case introduced by a small environmental NGO, the Urgenda Foundation, supported by 900 individuals. And the initial demand, which was introduced in 2013, was the demand that the Netherlands would be condemned to reduce greenhouse gas emissions with 40% and at least 25% towards the end of 2020, compared with 1990 levels. The court, the District Court of The Hague, in June 2015, ordered the state of the Netherlands to reduce its emissions with at least 25% at the end of 2020. And this case was based on tort law, and the District Court found that the state of the Netherlands has a duty of care in the matter of climate change to protect its citizens. And in that judgment, there was a lengthy discussion about the separation of powers and if the court judgment was respecting the separation of powers. And so the main argument of the court to say yes, that's the case, was that the means to achieve this result was left at the discretion of the legislators and the governments, so the legislator and the government can decide on the concrete measures to take. So this case was appealed, and the Court of Appeal in The Hague in October 2018 confirmed the judgment of the District Court, but the legal basis of the judgment has been modified. So the Court of Appeal based the judgment on Article 2, that's the right to life, and Article 8, that's the protection of privacy and family life of the European Convention of Human Rights, and to determine if the policies of the Netherlands was respecting those obligations. It referred to the IPPC reports and the Paris Agreement, which was seen was used to determine the minimum effort that the Netherlands should do in this matter. And so this judgment has been confirmed now on 20 December 2019 by the Supreme Court of the Netherlands. So the case is now final. And also in this judgment you can find a detailed discussion on the separation of powers and the duty of the judiciary to provide legal protection. What's the result of the case? It must be noted that the Dutch government had engaged itself already during the appeal and cassation procedure to obey the court orders. But the Netherlands has the fifth highest emissions per capita within the European Union, and looking to 2018, according to official figures, the Netherlands had already reduced its emissions compared with 1990 levels with 14.5%. So more than 10% has still to be done, so an extra action is needed, and we shall see if the Netherlands at the end of this year will succeed in executing the court order. Meanwhile, and under the influence of the cases, it's also important to note that in the Netherlands a comprehensive climate act has been passed in July 2019 with reduction objectives for 2030, a reduction of 49%, 2050, a reduction with 95%, and the main instrument are the periodic climate plans to be adopted, and also there is a room for climate negotiations between the government and the stakeholders, which can result in agreements to come closer to those objectives. Other cases that I can shortly mention, we have in Belgium the so-called Klimaatzaak, climate case. That's very similar to Uganda. It has also been introduced by a small NGO and is now supported by 60,000 co-claimants and supporters. It has already been introduced in 2014 as a civil case, but in a much more complex institutional setting in Belgium than in the Netherlands. Why? Because Belgium has a federal government and 3 regional governments, and climate change policy is a mixed competence, partially federal, partially regional, and some of those regional governments have introduced some procedural hurdles in the case. So meanwhile there are already 3 interim judgments on those procedural issues, including an interim judgment of the Supreme Court, and so the Supreme Court has now cleared the way for dealing with the substance of the case, and that's what's happening now. We are in the phase of exchange of arguments in writing between the parties, and the hearing the case is set for autumn 2020. The claim in this case has also been modified over time, and now the claim is that they're asking for a emission reduction of 42 to 48% in 2025, a reduction of 55 to 65% in 2030, and a carbon neutral Belgium in 2050. Another case is a case in Germany. The case is called Family Farmers and Greenpeace, Germany versus the German government. And there the claim was to increase the emission reduction from 32%, that's current policy of the German government, to increase it to a reduction of 40% in 2020. In October this year, there was a judgment of the Verwaltungsgericht Berlin, so the court, the administrative court in Berlin, and that court has dismissed the case, but it's important to note that the court acknowledged that climate change policy is judicially reviewable, should respect fundamental rights, and should be based on sound science, but the court found that the actual reduction objective of the German government, so the reduction of 32% in 2020, is not completely inadequate in the light of those principles. At the European Union level, that is the so-called People's Climate case. It's a case introduced by various environmental NGOs and plaintiffs, and the claim is to increase the reduction effort in 2030 to 50 to 60%. Meanwhile, there is a judgment because the case was first introduced with the Court of First Instance of what's called now the General Court of the European Union. That General Court dismissed the case for lack of standing, and that is based on the very strict Plowman test, so-called Plowman test on standing, and this means standing for direct action towards the European court, so direct access to the European court. But the case is appealed now to the Court of Justice of the European Union itself, and one shall have to wait to see if the court is prepared or not to modify its Plowman test in matters of climate change. Finally, some words about climate legislation. So the actual objectives of the European Union are the so-called 2020 objectives for 2020. This means a reduction of greenhouse gases compared with 1990 levels with 20%, a share of renewable energy of 20%, and an increase of energy efficiency of 20% and of this year. Meanwhile, also the objectives for 2030 have been approved. So in 2030, one is striving towards an emission reduction of 40%, a share of renewable energy of 32%, and an increase of energy efficiency with 32.5%. And in 2050, one should have carbon neutral Europe. But last year we had elections for the European Parliament, and on the basis of that a new European Commission, so a new government, let's say, has been appointed, and this for this new European Commission, climate policy and environmental protection has been put forward as a priority. And in December 2019, the Commission proposed its so-called Green Deal proposal, and that proposal includes an increase of ambitions. So in 2030, the objective put forward by the European Commission is to reduce greenhouse gas emissions with 50 to 55%. But of course, this is a proposal of the European Commission. This has now to be discussed and decided together with the Council, in which so the national governments are representative, and with the European Parliament. And on the national level, we see an increasing number of national climate change laws recently adopted. So following the example of the UK, so the UK Climate Change Act of 2008. So meanwhile, all Scandinavian countries have similar acts, strategic comprehensive acts, also France, and as I mentioned since last year, also the Netherlands, and now Germany has also adopted such comprehensive climate change act. So that's in a nutshell what's happening within the European Union on the level of litigation and legislation. Thank you for your attention.